Hello Esmeralda, good afternoon. My name is Kyron Sebastian Nagra. I am a trainee solicitor for Bodge, Stodge and Hassel. I am also a trained mediator. I am here today to explain to you the mediation process, which hopefully will help with your current situation as you have a dispute with your neighbour Anakin Skydiver. I'll then explain to you the advantages of using mediation and the process. Please note, Esmeralda, I am not a judge. I am a facilitator, therefore I neither represent you or your neighbour Anakin Skydiver. A mediator does not give any legal advice. I'll simply be enabling you and Mr. Skydiver the opportunity to avoid going through the court system in order to save you time, money and ultimately agreeing on a solution between yourselves. The mediation is split into 4 phases: the opening phase, the exploration phase, the negotiation phase and finally the settlement phase. This first stage, known as the opening phase, is the meeting in which both you and your neighbour Mr. Skydiver must be present for in order for the mediation to take place. I will introduce myself as the mediator, then outline the issue with regards to the dispute. As a mediator, I will explain my role as a mediator is not to side with either party, but to facilitate and aid an agreement between yourself and your neighbour Mr. Skydiver. I will outline key factors including the negotiations and opinions of both parties' ability to put forward their views and rebuttals against each party's claim. Interruptions must be avoided at all times in order to maintain respect for one another, who you are advised to write down your comments and opinions in regards to your issues at hand, which will be discussed after the party has finished speaking, and then you can address your concern. This will avoid conflict between each party and optimise mutual respect and opinions in order to increase the probability of a successful mediation. The exploration phase. During this stage, I will firstly speak to both of you as individuals in order to increase my understanding of both of your opinions and the case facts. After doing so, I will enable myself as the mediator to search for common ground and understand both parties' situations and opinions, which will help me make my case during the negotiation phase and look for common ground between yourselves. If both parties agree to do this, it will be followed by the negotiation phase. In this meeting, I will forward all suggestions and put forward both parties to enable the parties to consider, discuss and negotiate all issues. This process is a joint meeting to confirm the outcome of the success or unsuccessful of the mediation. The settlement phase is the last stage, which if successful I will enter into the mediation with the agreed terms. If successful, I will then draft the agreement of the mediation, and in order for the mediation to be enforceable, both parties will sign and agree the terms. If, however, the settlement is not reached, I will make a full account of why the mediation did not work, including all the information I have gathered and obtained during the mediation. There are various advantages of mediation. I will firstly discuss the advantages and apply them to your individual situation. Firstly, all discussions are confidential between me, the mediator, and the negotiation party unless I am expressly told to do so. This, of course, is the same between myself and Mr. Skydiver. A mediation, unlike the court system, is voluntary. I'll hold a private meeting with any party if you so wish to leave. However, if you still do wish to leave and believe that the negotiations are not going well or are not worthwhile, you'll not be bound by any information you have discussed during a mediation, which can also not be held through the court system. The mediation can actually be very quick and cost effective and could save you time going through the court system. Some previous cases regarding boundary disputes have amounted to thousands of pounds in some cases, which can actually take several months to resolve, whereas the mediation sometimes it can be done within hours. The exact legal boundary is very difficult to determine as both parties are registered, and the solution could take a long period in comparison to mediation. Mediation is private, unlike the court system, and some mediation processes can be very time efficient. The legal boundaries, as I explained before, can be very difficult to determine. For example, deeds, plans and conveyances may conflict or contradict with each other. Additionally, if you go through the court or either through a party attempts to sell the property, legally you are obligated to disclose to disclose any potential disputes that you're going through the court system. I hope you take my suggestions of the mediations on board, and if there are any questions regarding the mediation process, please contact me at your earliest convenience. Hello again, Esmeralda. Good afternoon. I'm happy your mediation was successful. I've drafted the mediation agreement between yourself and your neighbour, Mr. Anakin Skydiver. The first stage I'll be discussing with you of the draft agreement is the rhetoric stage, who the parties are, which are stated, you, Esmeralda Earwax, and your neighbour, Anakin Skydiver. This section also states the reasons of the dispute, the key issues which are addressed. These include the parking, the fence being built, the smell of the dustbins, the dog barking and excrements, and the loud music, and finally the new fence being built. The fourth section explains the agreed terms both you and Mr. Skydiver have agreed to, which are as follows. Firstly, the boundary area will be divided as prior to the fence being built. The issue of the loud music being played should only occur between the hours of 9 AM and 10 o'clock at night. And as a general rule, Mr. Anakin Skydiver must also do his best to close all of the windows and doors whilst playing music. During parties and events, Anakin must inform Esmeralda, yourself, that music may be played loudly in advance as a general courtesy. Esmeralda's dog must attend training school in order to reduce the noise of the barking. Additionally, at training school, Esmeralda's dog will be trained with puppy mats, excreting only in designated areas. Furthermore, any excrements left outside the property or near Anakin's property must be disposed of as soon as possible. Esmeralda must ask Mr. Skydiver's permission before her or any of her visitors use Mr. Skydiver's drive or parking areas. Additionally, as a compromise, Mr. Skydiver, with permission, must ask Esmeralda to do the same if he would like to use her land for parking. Anakin must dispose sensibly of all waste and rewrap any food containers before depositing them into the bins. Esmeralda must also take into consideration this may not always stop the smell, however it will reduce the chances. Mr. Skydiver will finally continue to build his fence, however it must be built in a way that both parties have enough space to park the vehicles, taking into account consideration Esmeralda's back problem. After you have both agreed and signed these terms, the mediation is binding between both parties. The final part of the mediation is the clarification that the mediation will be binding when signed and agreed. Furthermore, any information disclosed or prior to the mediation cannot be used in any judicial or arbitral proceedings. They must be kept confidential. Now you must sign and agree the mediation binding you and Mrs. Skydiver to the draft agreement, meaning you must comply with the draft agreement and it is legally binding. I'm now explaining to you, Esmeralda, the mediation process and the importance to sign the draft agreement, as if you do not do this, this could lead to a very costly and time-consuming court case. I hope all of the issues are resolved and you sign the draft agreement, and if you have any queries regarding the mediation and not legal advice, please do not hesitate to contact me. Thank you very much.